Let's talk about motions to reopen in light of the U.S. Supreme Court decision in Chavez v. Garland. So what's going on is that you might have heard about it. People are reopening their cases. Prosecutorial discretion is in order. And some people are wondering, am I qualified? What should I do? I've been receiving emails and I've been receiving phone calls. So I decided to just address this once and for all. Let's get right into it. What's happening is that we all know that on April 29, 21, the Supreme Court decided in Chavez v. Garland that this is a case involving eligibility for cancellation of removal. We already know what is cancellation of removal. Cancellation of removal is basically if somebody find themselves in removal proceedings and happen to be here for continuously living here for 10 years, they can ask the judge if they've exhausted all their options. They can ask a judge as a form of relief to cancel the removal so they can adjust status. But remember that with cancellation of removal, okay, the 10 years period is prior. It's not after. It is prior to the date of receiving the notice to appear. So you have to count the days prior to the notice to appear. That's how it works. But what happened in this case of Chavez v. Garland is because they went all the way to Supreme Court because Chavez received a defective notice to appear. So the notice to appear has to have the time, the date, and the place of the hearing in one notice, not two separate notices. So in one notice, you should have the time, the date, and the court hearing. So the court where you're going to go to the hearing. But unfortunately, Chavez received a defective notice. That's why he wanted, I don't know if it's she or he, but anyway, the person wanted to tell the court that no, your notice was defective. I received multiple notices with no date, pretty much with no time as well. The notice was defective. Therefore, you cannot count my date after the date I've received the notice because you cannot count my date prior because the notice was defective. So you have to count all those years until I actually receive a real notice. Therefore, I've met my requirement. The 10 years continuous residency has been met. So therefore, I need to cancel this removal. That's what exactly happened. Okay. So here it's just to reiterate, these proceedings proceedings that requires non-citizens to demonstrate that they have accrued a specific period of continuous residence or continuous physical presence in the United States, which is 10 years of physical presence, continuous physical presence. Of course, if you have been out probably less than 180 days in aggregate, it's not gonna really affect you, right? But if it's more than 180 days in aggregate or in one setting, then it will affect the case. But anyway, so the two-step process really, it says that the notice to appear for removal proceeding does not include the time and the place of the first removal hearing. The immigration court later serves a notice of hearing providing that information does not trigger the stop time rule, that cutoff of the non-citizen accrual of the required time. In simpler terms, if the court has given you a notice without including the time or the place of the first removal hearing, and then later on they come with a second notice that includes the time, unfortunately, they're not going to come to tell you that they have triggered the stop time rule. So basically, until you actually receive a real notice with everything included, all the years prior to that date should be included in counting your years of continuous residency. That's exactly what it means. Residency of 10 years is counted prior to you receiving a notice to appear. However, if you receive a notice to appear and the notice is defective, you are still going to count those days and those years even after receiving a defective notice. That's exactly what happened. So previously, some people were denied cancellation of removal, and now because of this decision of the Supreme Court, they can go ahead and actually pretty much with this decision of this U.S. Supreme Court, they can go ahead and reopen the case. And remember, we have prosecutorial discretion going on too, which means that they can actually reopen the case and to address that, those such cases that those people couldn't actually get that type of relief, cancellation of removal. It says that to address those cases, 180 days from the date of the Supreme Court decision, pretty much until November 16, 2021. So if you look at your notice to appear and it was defective, and you have really come up with 10 years of continuous residency, and you really want to apply for cancellation of removal, you can go ahead and open the case and apply for cancellation of removal. Okay, ACE attorneys handling removal cases before the Executive Office of Immigration Review will presumptively exercise their prosecutorial discretion to join or not oppose a motion to reopen filed by such non-citizens who demonstrate that they are prima facie eligible for cancellation of removal. So that's when prosecutorial discretion came into play. So basically, they are going to see whether they can reopen your case or not. But in those cases, really, chances are, if you have met prima facie eligibility, you have shown that, really, they are going to reopen your case, to be honest. And they are going to actually, what you need to do, you have, if you haven't done so, you need to submit the complete cancellation of removal application along with any required supporting document. Okay, and then what's going to happen, consistent with applicable guidance on the exercise of prosecutorial discretion, including the May 27, 2021, they are going to basically decide on your case on the merit. Okay, so it says if the such motion to reopen is granted, eligible non-citizen will have the opportunity to present their cancellation of removal claim to an immigration judge and receive a decision on the merit. Simply means that they are going to look at your case and give it its full attention and decide whether cancellation of removal can be granted to you or not. Okay, so, and that's it. And then they're asking, if you want to join a motion to reopen, you should be directed to our, it has to be directed to the ICE office of the principal legal advisor field location. So that's it. That's all I wanted to talk about. Really, to sum it up, I wanted to talk about case reopening and prosecutorial discretion. They're using prosecutorial discretion to decide whether they can reopen the case or not, especially for those who previously could not qualify for cancellation of removal based on continuous residency. But now that they have cleared this one up, if the notice to appear was defective, as a matter of fact, you should be able to meet those requirements of 10 years continuous residency, and therefore apply to reopen the case. And based on prosecutorial discretion, they will decide whether to reopen your case or not. But anyway, if the case is reopened, then the judge is going to decide on the merit. They're going to look at the case and decide whether they can grant you cancellation of removal or not. So that's for reopening cases. But as far as a new memo, when it comes to prosecutorial discretion, what it simply means is that ICE or the DHS can basically decide if somebody is in removal proceedings, whether to continue to pursue them or to settle the case outside of the immigration court. And in the memo, they told us who actually can be qualified. They talked about, firstly, permanent lawful permanent resident that find themselves in the removal proceeding can be qualified for that prosecutorial discretion. Elderly, pregnant women, or people who've been here since they were younger and now find themselves in removal proceeding, they can really ask to their lawyer to try to see whether or not they can ask the DHS or the government to drop the case and settle outside of immigration court. And the way this one works, pretty much to give you a specific example, it could be like somebody has a child who's turning 21 and now they find themselves in removal proceedings, and based on this prosecutorial discretion, they can just ask the government to drop their removal proceedings, to cancel it, so they can adjust status with USCIS. That's one specific example. Or maybe a pregnant woman who can actually claim as one of their defense, they can claim extreme hardship. So they can, and now that they can claim extreme hardship, and they have other ways, or pretty much to adjust status, they can really ask government to drop their case so they can settle outside of immigration court and pursue their adjustment of status with the USCIS. So those are specific examples when it comes to prosecutorial discretion. So basically the power of government to drop a case, to decide whether to prosecute a case or not, and they're really basing it on certain element, humanitarian crisis, or pregnancy, or elderly, being here for a long time, really health reasons, serious health reasons, stuff like that. You can ask to drop the case, especially if you have another way to adjust status. You can ask them to drop that removal proceeding, settle the case, and then adjust status with USCIS. So that's it for today. Today's Sunday. I'm not gonna take that long, but I wanted to clear things up. And really, if you really need consultation, next week, unfortunately, I'll be out of the office the full week because I'm going on vacation. I am really have to take a break to resources and stuff like that. But when I come back after Father's Day, we can start probably we're going to start our live sessions, and we'll answer some of those questions again. But you're welcome to email or call, but unfortunately you might not get my email back or an answer until the week of June 2020. Okay, Bijoux Ngwanda, immigration lawyer in the DC metropolitan area. This was U.S. Immigration. Until next time, bye bye.